today we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnicky. Good morning, Ms. Winnicky, and Bernice Corley. Good morning and welcome.
Justices, I would like to begin by correcting the record. The judge says that we don't know what RichardAllen's wishes were, and the Attorney General says nothing is clear. On October 11, 2023, RichardAllen filed the following. Dear Judge Galt, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other. Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. To do a half measure is to credit the judge and the attorney general for allowing this to happen. Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their client's wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what our ethical rules require them to do, which is to give zealous advocacy for your client. And those gentlemen, when faced with a real tough call, they showed up on October 31st and said, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th, could not have been more clarity on October 19th. There could not have been more clarity on October 31st, and if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. They're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what Wheat is clearly about. Would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Massa and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective, but absolutely a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. My troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client and trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as relating to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice prong. But yes, if these things could ever arise to ineffective assistance of counsel, and justices, I'm not conceding that, but if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept RichardAllen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration, and we ask you to grant the relief we've requested. Thank you very much.
Thank you, counsel.
We have some breaking developments tonight. Indiana Supreme Court issuing decisions
That Allen's request to reinstate his former attorneys will be granted.
Just late this afternoon, the Indiana Supreme Court announced that it is now reinstating Richard Allen's original defense team.
They'll never take me alive, I'm getting high with my 4-5. Dropped on these suckers time I die, even as a youngster. Causing ruckus on the back of the bus. I was a fool all through high school, kicking up dust. But now I'm labeled as a troublemaker. Who can you blame? Smoking weed help me take away the pain. So I'm hopeless, rolling down the freeway, swerving. Don't worry, I'm about to crash upon the curb, cause my vision's blurry. Baby, if they tried to understand me, what should I do? I had to feed my fucking family, what else could I do? Or be a thug? I'm slanging with the homies, fuck hanging with them phonies in the club. Got my mind on danger, never been a stranger to homicide. My city's full of gangbangers and drive-bys. Why do we die at an early age? He was so young, but still a victim of the 12 gauge. My memories of a corpse, mind full of sick thoughts, and I ain't going back to court. So fuck what you thought. I'm drinking Hennessy, running from my enemies. When I live to be 23, there's so much pain.